Hello, my name is Jesse Schley, and I am in my third and final year at the University of Pennsylvania Law School. Today, I am going to be discussing the landmark case of Gideon v. Wainwright, decided in 1963, a case dealing with the constitutional right to counsel. Before discussing the facts of this case, it is important to cover some of the constitutional issues at play, specifically the 5th, 6th, 10th, and 14th Amendments. First, the 10th Amendment and the question of federalism. The concept of federalism is basic to our system of government. It means that there are two government structures, the states and the federal or national government. The power of states are expressly preserved in the 10th Amendment to the Constitution, which states the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. The explicit protection of states' rights was so important to the Founding Fathers that it led to the passage of the 10th Amendment, which established the concept of reserved powers or police powers as distinguished from delegated powers of the federal government. The sovereignty of each state created by the Constitution and the 10th Amendment continues in importance today. This is because much of the law and regulation that govern our everyday life comprises of state and not federal law. For example, criminal law presents the broadest area of state power. What is a crime, what are the defenses, and what are the punishments for a crime vary from state to state. For example, a person convicted of murder may be sentenced to death in Texas, but not in New York, which has abolished the death penalty. Further, the very structure of the court system varies from state to state, as does the process that a criminal defendant will experience. In Gideon, the 10th Amendment issue is whether the state has the power to determine if indigent or poor defendants in criminal cases should be provided free counsel. This leads to the next constitutional amendment at issue, the 6th Amendment. The 6th Amendment states, "In all criminal prosecutions, the accused shall have the assistance of counsel for his defense." Thus, the question becomes, do states have to provide paid counsel under the 6th Amendment? Meaning, does the 6th Amendment apply to states? To answer these questions, it is important to look at the 14th Amendment and how the 6th Amendment has become applicable to states. The 14th Amendment, which is one of the amendments passed shortly after the Civil War, explicitly applies to states and conveys that no state shall deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. The phrase due process of law is the exact expression used in the 5th Amendment, which says in pertinent part, no person shall be deprived of life, liberty, or property without due process of law. Thus, we have two amendments with the same phrase, due process of law. Is the Constitution just being redundant? No. Remember that the 5th Amendment is part of the Bill of Rights, which was originally intended only to apply to the federal government. Conversely, the 14th Amendment was intended to apply to the states and not the federal government. In a sense, the due process clause of the 14th Amendment is meant to grab all of the key provisions found in the Bill of Rights and make them applicable to the state. Thus, in Gideon v. Wainwright presents the battle of the 6th Amendment versus the 10th Amendment. Is the right to counsel a fundamental right which applies to the states? And if it does that right outweigh state sovereignty? Does the right to counsel require the state to provide counsel to indigent or poor defendants? And if so, for all criminal defendants, whether they are accused of a felony or just a misdemeanor? Now, before answering these questions, let's look briefly over the facts in Gideon. Clarence Gideon was arrested and charged with breaking and entering an intent to commit petty larceny in Florida. Gideon could not afford a lawyer, and he asked the court to appoint a lawyer for him, but his request was denied because under Florida law, the court could only appoint counsel in capital cases or murder cases. Gideon represented himself at trial, and he was ultimately convicted by a jury and sentenced to 5 to 7 years in prison. Gideon filed a petition for writ of habeas corpus with the Florida Supreme Court, arguing his right to counsel was violated by the trial judge's refusal to appoint a lawyer. The Florida Supreme Court denied his petition, and Gideon filed a petition for writ of certiorari with the United States Supreme Court, which was granted. The question before the court, and before you now, is whether the 14th Amendment incorporates the 6th Amendment right to counsel and makes it applicable to the states. If you are arguing on behalf of Gideon, you are arguing that the Sixth Amendment right to counsel must trump a state's right to its own sovereignty under the 10th Amendment. If you are arguing for the state, you are arguing that the right of a state to govern itself under the 10th Amendment is paramount over the Sixth Amendment right to counsel. The precedent of Batts v. Brady supports the state of Florida in holding that the state was not required to provide paid counsel for an indigent defendant unless special circumstances existed. If you are arguing for Gideon, you must argue that Batts should be overturned. And if you are arguing for Wainwright, the state, you must argue that Batts should stand.